decisions when, in fact, every one of the decisions that I've given you in your written materials begin right at the top with this notice in bold print, right? It says notice. This order was filed under Supreme Court Rule 23 and may not be cited as precedent by any party except in limited circumstances allowed under Rule 23(1). So why are we talking about cases that cannot be cited as precedent? Well, let me give you at least 3 reasons that I think we should be talking about these cases, and maybe you can come up with some more. First of all, they're interesting, right? I mean, these are some pretty interesting cases. There's some pretty interesting fact patterns we're going to be talking about in these cases. They deal with interesting issues that we run into every day in our practices, so they're fun and interesting to talk about, at least in my work, opinion work. It's fun and interesting. So, the second reason I think that it's good to talk about these Rule 23 decisions is that they often, and I think in the 4 cases we're going to talk about, all include really good, concise summaries of the issue of law that they're discussing, right? So when we're talking about 2 repetitive trauma cases, there's a paragraph in those cases that talks about the law as it relates to repetitive trauma. We're going to be talking about a jurisdiction case. There's a really great paragraph that summarizes the jurisdictional factors for the principally localized type of jurisdiction under Illinois law. So these cases really contain some very nice, concise summaries of what the law is. And you can use those summaries, right? Because the cases that are cited in the Rule 23s are actually citable cases, right? So you can just with that paragraph, if you want like an introductory paragraph, for example, in a proposed decision about repetitive trauma, right? What do you have to prove for repetitive trauma? You can lift the paragraph right out of this Rule 23 and plug it right into your proposed decision. It's a really, these cases seem to be really good tools for doing something like that. And frankly, the third reason, which is the honest to God reason why we're doing this, is because the appellate court just isn't publishing that many decisions. In fact, as far as I can tell, there hasn't been a published decision for about the last 4 months, at least, maybe even 5. So if we didn't talk about Rule 23 decisions, we wouldn't be talking about appellate court orders or appellate court reasoning. So that's the last reason, which is the honest reason that we need something to talk about, and these are the cases that are available to talk about. So, when you talk to the appellate court, and we do just about every year when we have our WICLA luncheon, there's almost always a question to the justices about, well, what about Rule 23s? Why don't you write more decisions? Why do you write so many Rule 23s? And I don't think that the answer we get is very satisfying often. But we're almost always directed back to the rule itself, right? So, Justice Holdridge might say something to us like, well, look at the rule, and you'll see why we write so many Rule 23 orders as opposed to published decisions. So I'm going to take Justice Holdridge's advice for once in my life, and we're just going to look very quickly at what the rule says. Okay, so Rule 23, of course, is a Supreme Court rule. Everybody knows that, right? Opinion. A case may be disposed of by an opinion only when a majority of the panel deciding the case determines that at least one of the following criteria is satisfied. So there's got to be a majority of the panel that says that it should be a published decision. And here's what the standard is for a published decision that a majority has to agree on. The decision establishes a new rule of law, or modifies, explains, or criticizes an existing rule of law. So the modifying, criticizing, is probably a pretty high standard. But the explains, I think you're going to maybe agree that some of the cases we look at, maybe all the cases we look at today, explain what the law is. Okay, or the decision resolves, creates, or avoids an apparent conflict of authority within the appellate court. So I'm not sure that any of these cases do that, but those are the standards that have to be met in order for a decision to be published as opposed to being a Rule 23. Otherwise, the presumption, I guess, is that it should be a Rule 23 unless it meets these standards according to a majority of the court. So let's just take a quick look at what is the effect of a Rule 23 order. An order entered under Subpart B, which is Rule 23, of this rule is not precedential and may not be cited by any party, which we've already said, except, okay, so here's the exception to the rule. To support contentions of double jeopardy, we don't usually have that in workers' compensation case unless the petitioner has committed fraud of some kind, right? So we don't usually have double jeopardy, and that was a joke, by the way. Believe it or not. Res judicata, right? So if it's an issue that's already been decided between those parties, the same issue, collateral, estoppel, or law of the case, right? So those are the exceptions to the Rule 23 not being precedential. And so those things probably make sense. You do have an opportunity to file a motion to publish a Rule 23 order, right? So if you get a Rule 23 order and you, as one of the attorneys involved in that case, think you want to get the case published, right? You can file a motion to publish the Rule 23. It shall set forth the reasons why the order satisfies the criteria for disposition as an opinion, so those standards that we just talked about, and shall be filed within 21 days of the entry of the order, right? So be careful because this is a little bit of a short time frame, 21 days if you want to file that, right? So, question after Rule 23 is entered, right? Do the other appellate court procedures apply to Rule 23, right? You know, filing a motion for reconsideration or filing a motion for certification of that decision so that you can file a PLA to the Supreme Court, right? Yes. So the rules, the post-appellate court rules apply to Rule 23s just like they do to published decisions. Now, if you got a Rule 23 and you're asking for a certification of that in order to file a PLA to the Supreme Court, and you've already filed a motion to publish, which has been denied, my guess is that your motion for certification by the appellate court is probably going to be denied too. Okay, so of course you have to take all of those factors into account, but be aware of the time frames that apply to Rule 23s are just the same as apply to published decisions, and there's this motion to publish, which is 21 days, which is a little bit of a short time frame, okay? Anybody else have any comments on the procedures? Anybody ever filed one of those motions to publish? Anybody been successful in getting it published? So yeah, so there's a few lawyers here who have actually succeeded in getting their cases published. Did that case go any further? Did it go to the Supreme Court? Okay, so the answer is no, right? So okay, you won, but you lost, right? You got it published, but you're not going any further. Okay, all right. Anything else about the rules or procedures? All right, good. Let's talk a little bit about the cases then. So the first case we're going to talk about is John B. Sanfilippo versus Workers' Compensation Commission, and it's a 2018 case that came down. All of these cases came down in July, so within the last 30 days or so. Of course, in this case, John B. Sanfilippo is the name of the employer, right? So this is the petitioner's appeal to the appellate court. This is the employer's appeal to the appellate court. And what the appellate court is dealing with here is a Workers' Compensation Commission finding in favor of the petitioner that the petitioner sustained a repetitive trauma injury and had fixed that repetitive trauma injury on a particular date. And what the appellate court ultimately ends up doing here is affirming the commission's affirmance of the arbitrator's decision awarding benefits in the case. And we're going to talk a little bit about the arbitrator's decision in just a second, because I think there's a couple of interesting things to point out there. So this is a case where the appellate court affirms an award of benefits to the petitioners on a repetitive trauma theory. Let's just take a quick look at what the facts of this case are so you get some idea of why the ultimate date of manifestation is the date that the appellate court is able to affirm. So this petitioner, who is a janitor, first says that she notices pain on October 9, 2013, and she seeks treatment from her primary care physician. And in the records of the primary care physician on that very first day, there is some reference to the types of activities that she does at work, right? So there's no explicit causal connection opinion given by the primary care physician at that time. But, you know, it's one of these things where it's referenced, right? So, you know, the petitioner is noticing pain in her right shoulder and in her back, and it seems like that pain increases when she does work activities as a janitor at John D. San Felipe, right? And her testimony ultimately is that she's a janitor there, and she's required to do a lot of overhead activity, right? When she's washing down the walls or cleaning light fixtures or things like that, she's doing a lot of overhead activity that she says has injured her right shoulder. So she gets a note from the primary care physician on that first date that she sees the primary care physician, who says that maybe it would be better if she were doing something other than the janitorial duties, especially a lot of the overhead lifting. She brings that into work, and she gives it to the supervisor on October 23rd, 2013, so about 2 weeks later or so. And the supervisor, who testifies at the hearing, as far as I can tell, acknowledges, yeah, he got the note, right? But he didn't really realize that what she was doing at that time was reporting a work-related injury, right? She presented a note that said I should probably be doing some type of lighter activity, and they apparently accommodated her at the job. They at that time, sometime in mid-October, according to the decision, they allowed her to no longer work as a janitor, but now work as a capper on a line which they consider to be a little bit lighter work. So finally, in November, on November 22nd, so about a month and a half or so after she originally goes to her primary care physician, she finally goes to the employer's clinic, for lack of a better phrase, right? She goes to physician's immediate care, right? And there she gives, or there's noted in the record, a history of work-related injury, quote-unquote, gradual onset, right? So she didn't say, I got hurt today at work. By the way, she had already been moved into the captain job, right, into the lighter duty jobs, and when she first goes to physician's immediate care, she's already working as a captain, right? And so when she goes there, she says, I've had this gradual onset of pain in my right shoulder. Finally, in February of 2014, so about, 5 months after she originally goes to her primary care physician, she's seen by Dr. Levy, right? And Dr. Levy recommends shoulder surgery, right? So over the course of time, right? Not that very first time, but treats her up a little bit, works her up a little bit, and then ultimately recommends shoulder surgery. Petitioner, the case is denied, right? And so petitioner is requested by the respondent to go to see Dr. Baer for an IME. The IME takes place in March of 2014, and you can read how Dr. Baer's opinion turns out in the decision. I'm giving you all the decisions in the written materials there. But, honestly, Baer seems to be all over the map on this one, right? First he says it could have aggravated, her work activities could have aggravated an existing problem. I don't necessarily see a specific injury, but maybe the work activities were an aggravating factor. He then files an addendum that says, no, there is no causation, but, and he's opposed, and when he's opposed, he says, well, maybe possibly there is, but I don't think so, and so he just seems to be kind of all over the map. The petitioner goes to see Dr. Cummings for an IME, so not for treatment, just for an IME, gets a causal connection opinion from Cummins, who's deposed in the case, and Cummins says certainly this overhead activity of washing down walls and other things that the petitioner has to do when she was a janitor, the overhead activities can be a cause of a causative factor anyway, aggravating factor in the fact that she's got a torn rotator. Okay, so that's the setup, right? The petitioner files a 19B, tries the case on 19B. The case is being tried for temporary total disability benefits and the prospective medical treatment that Dr. Levy has prescribed, the arthroscopic shoulder surgery. But I do want to just take a minute to take a look at the arbitrator's award, and I give you a copy of it in there if you can find it. In this case, the arbitrator does award the prospective medical, okay, but only for the shoulder, right? The petitioner is also alleging that she's using her right knee in these repetitive activities, and the arbitrator specifically finds that the right knee is not related and she doesn't need any, surgery for her right knee, but does find that the shoulder injury is related, causally connected to repetitive work activities, and awards the prospective medical. I want to just point out a couple of things in the arbitrator's decision, though, and so the issue comes up sometimes, right, in the 19B, what are you really trying? I mean, are you trying all the issues up to that point? Are you trying just the issues that you want to try? Are you, are you waiving other issues? Like if you don't put them into evidence right at that time, are you waiving those issues? And this often comes up in terms of medical bills, right? So the medical bills that the petitioner had already incurred, right, up to the time when she tried the 19B, she wasn't trying the case for that, right? She was trying the case for the prospective medical, that Dr. Levy had recommended. And when I first saw that, I wondered, how can that be? And if you look at the arbitrator's decision, you see why it is, right? It says, the parties agreed to reserve ruling with respect to all issues related to medical bills for determination at a later date, right? Which was honestly a little bit surprising to me, right? Because I'd always heard this idea that if you didn't put in all your medical bills at the time of the hearing, medical bills that had already been incurred, that you waive that, right? That you waive that. Well, here's a decision that's affirmed by the commission that says that maybe if you get an agreement to reserve that until a later date, you can try your 19B if you're trying it for prospective medical without all the medical bills that have already been incurred. Okay, so that struck me as something pretty interesting in the 19B decision. In a case like this, right, where it was really about the accident and about causal connection, right, it really wasn't about the bills, I suppose, until the respondent was declared liable for the payment of the bills, right? It isn't really about the bills until it is about the bills, right? So the other interesting thing about this arbitrator's decision is the very next paragraph, right? Petitioner was granted leave to amend the date of accident from November 21, 2013, right? So the day that she goes to that physician's immediate care, right, the employer's clinic, right? The petitioner was given leave to amend the application, apparently at the hearing, as far as I can tell, to change the date of injury to October 9, 2013, right? That very first day that the petitioner saw her primary care physician, all right? And it says the respondent had no objection, all right? So here's the question. What if the respondent had an objection, right? What if the respondent said, I object? What could the arbitrator have done at that point? Could the arbitrator have said, I'm shutting this whole thing down until I rule on the amendment? Or could the arbitrator have said, okay, motion to amend denied, but when I write the decision, I'm going to write the decision to conform to the proofs, right? And if the proofs show that the actual injury date is October 9, 2013, what difference does it make whether the petitioner had amended the application, right? So it just struck me as interesting that, that there was this idea that the application was amended, I think on the date of the hearing, to pick out that manifestation date, which ultimately gets affirmed by the appellate court. Yes?
But obviously they didn't agree to that. So there, the other order will agree. There's a petitioner have a right to say, I'd like to file a new petition or an amendment.
Yeah. And yeah, I suppose, but then I guess what would have happened then is that the hearing would have had to have been continued, right? So in order to get all that kind of housekeeping stuff done. And I think, well, I never thought you need to leave, right? I file those amended applications all the time where with the yellow highlighter, and I just file them, right? I hope I haven't done anything wrong, right? So, but I think this one was because it was right at the date of the hearing. And you're going to see in the next case that we talk about how, a petitioner can get in trouble with the accident date, right? Especially if the petitioner is insisting that on November 21, 2013, that was a specific injury, right? It was a specific injury that happened on that day when, in fact, it really is all about a repetitive trauma that actually began a month earlier, right? You're going to see how, because this one, the petitioner wins the case, but in the next one we talk about the petitioner loses, and you're going to see maybe why the lawyer in this case thought it was so important to formally amend the application so that his petitioner maybe wouldn't get cross-examined with this idea that, well, you're insisting that it was a specific injury date on November 21, 2013, aren't you? Which you're going to see in the next case, the petitioner stuck with that and may have lost because of it. Yes?
Yeah, but I would agree discount store the day that the doctor knows the patient that this is work-related. The Supreme Court has told us that we have to do it every day. So if the amendment was going to happen, November the 22nd, or
so, Andy says, it's the date on which the doctor told the petitioner that it's work-related, that's the date of manifestation, okay? Which is a great segue into the next slide. Did you have a question? Or somebody up there have another comment or question to make? Okay, so let's look. Here's one of these situations where there's a couple of nice statements of what the law is in this Rule 23 decision. Okay, compensable injuries under the Act may arise from a single identifiable event to be caused gradually by repetitive trauma, right? Citing the Edward Hines case, right? So that's a really good, introductory paragraph that you may want to put in your next repetitive trauma proposed decision, right? It doesn't have to be a specific injury. Everybody knows that, but it doesn't hurt to cite a little law, when you say everybody knows that. It's common knowledge. And by the way, here's the case that stands for that proposition, right? Okay? An employee who suffers repetitive trauma injury may apply for benefits under the Act, but must meet the same standard of proof as a claimant who alleged a single definable accident, right? So, must meet the same standard of proof. I'm sure the respondent lawyers are going to focus on the word must, right? You must meet the same standard of proof. Good. I agree. But my focus as a petitioner's lawyer is going to be on the same standard of proof, right? So I think sometimes there's a misunderstanding or misconception or misapprehension out there that somehow repetitive trauma cases are harder to prove than specific injury cases, or there's something extra you have to prove in a repetitive trauma case as opposed to a specific injury case. Well, here's the appellate court citing the law that says it's the same standard of proof, okay? The same standard of proof as a single definable specific injury. Okay, so respondents say, you got to meet your burden of proof, and I say it's the same standard of proof as it is in a specific injury. The next part goes to what Andy talked about, right? So what's the date of manifestation for a repetitive trauma injury, right? What's the date that you have to pick as your date of accident? Here's what the appellate court is telling us the law is, right? The date when the injury manifested. okay? The date on which both the fact of the injury and the causal relationship of the injury to the claimant's employment would have become plainly apparent to a reasonable person. Not to that petitioner, right? Not to the petitioner's doctor, right? To a reasonable person. That's the objective standard, right? The reasonable person standard is an objective standard. If we remember back to law school, right? The reasonable person standard is an objective standard. So it's when it would have become apparent to a reasonable person. You know, is one of those dates when the petitioner's doctor tells her that this is related to the injury? Yes. But if you remember, in this particular case, when she first saw the primary care physician, he didn't tell her it was related. He took down her complaints, right? Her complaints were, when I'm doing this kind of thing at work, right, my shoulder hurts more, right? And he didn't say, and therefore I find that this is causally connected. And I told the petitioner that, and I've given her a note to bring to her boss that says that, right? So, the question becomes, when does a reasonable person, when would a reasonable person know that they have an injury and that it's related to their work activities, okay? So it's a reasonable person test. It's not when she knew, it's not when the doctor would have known, it's not when Dr. Baer, the IME, would have guessed that she knew or anything like that. It's when a reasonable person would have known, okay? So keep that in mind. And in this case, the appellate court says that a reasonable person would have known on October 9th, 2013, and therefore the commission's decision is not contrary to the manifest weight of the evidence. Even though there's some conflicting evidence about when that manifestation date might have been, right? Because there's this idea that she doesn't go to the employer's clinic until a month and a half later, right? In between, she's continuing to work. In between, she gets shifted to this other packing job. So I suppose, could any one of those other dates been a manifestation date? Maybe, right? Maybe. But I guess it doesn't matter as long as the petitioner picks one of the right manifestation dates, right? Except, when might it matter, right? So anybody want to take a guess at that? When might it matter if there are multiple manifestation dates, right? There's many dates on which a reasonable person would have known, right? What difference does it make which manifestation date? Yes?
Be a coverage issue.
What?
There could be a coverage issue.
So a coverage issue, right? So he's actually right on point, right? What if, okay, it's the same employer, but two different carriers, right? Two different carriers for that, for you know, a date of accident here or a date of manifestation here, right? Yeah. So Mike's got another one, right? Notice and statute of limitations, right? What if there's a manifestation date that's outside of the statute of limitations? Right? What if there's a notice date or a manifestation date that doesn't comply with the 45-day notice requirement, right? Maybe there's a different manifestation date that would comply with the notice and with the, right? And with the statute of limitations, right? Because if it's the date on which a reasonable person would have known, maybe there are many dates on which a reasonable person would have known, right? So it's just something to keep in mind, right? Yeah, Andy, Jay.
Employer of last exposure.
So Dan's got another one, right? The employer of last exposure, right? Who's going to get stuck with this thing, right? And if you remember, when we talked about legislation about a year ago, right? There was a piece of legislation that was passed and then vetoed, but that gave respondents an opportunity to seek contribution from other employers, right? So an employer might say, hey, why, just because I'm the last guy in line here, why am I getting stuck? Let me see if I can stick somebody else with a manifestation date and get some contribution for this thing. Okay, so that's an important issue, and it's actually on the mind of the legislature about, you know, sticking the last employer with the exposure on a repetitive trauma case, because we know that, you know, the appellate court has said Yeah, it doesn't matter if you work there 1 hour, or if you work there 1 week, or if you work there 1 year, right? If that's a manifestation date, and it's causally connected to that manifestation date, last employer, you're on the hook. By the way, even if the petitioner doesn't bring her case until 6 months after you fire the petitioner, right? So those are all really important issues that this Rule 23 kind of brings to mind, right? So again, that's why we're talking about Rule 23. Okay? All right, good. So let's move on to the next one, because this is the Campbell case, which is the opposite of the San Filippo case that we just talked about, right? So in this case, the petitioner loses the repetitive trauma case, and let's see if maybe we can tease out a few of the reasons why there's a difference between the result in these two cases. So in this case, the petitioner's alleging repetitive trauma, and I want to talk a little bit about what exactly is alleged and what it means to allege repetitive trauma when we talk about the arbitrator's decision in this case. But in any event, petitioner alleges repetitive trauma. I think it's a bad injury, if I'm remembering correctly. Alleges repetitive trauma. Loses the case in front of the arbitrator, loses the case in front of the commission. Ultimately, the appellate court affirms the denial of benefits in this case. So again, the opposite of San Filippo. All right, the petitioner was a pickup driver, a delivery truck driver. Every day or week, filled out vehicle reports, and these vehicle reports would be defects in the vehicle. Right, so. He'd say, you know, there's a defect here, a defect there. His testimony was that a lot of the trucks he worked on, the doors stuck, right? So he'd really have to pull down hard on the doors, and that was part of the repetitive trauma to his back. And apparently, the significance of these driver vehicle reports was that he didn't always put that in the driver vehicle reports, that there was a flaw with the door, right? So maybe that was, you know, somehow inconsistent with his testimony about, you know, the activity that he was doing. He first started noticing pain in his back in 2009, but he doesn't receive any medical treatment or talk to a doctor about it until January 23rd, 2010. According to the record in this case, as far as I can tell, that's the first time he talks to a doctor. He goes to his, again, primary care physician, which seems to be pretty common in these repetitive trauma cases, right? The petitioner is not necessarily thinking about going to see an orthopod or a hand surgeon. Goes to the primary care physician because he's feeling a little bad or whatever, right? The primary care physician in this case, history is, quote unquote, back and neck hurt from performing duties as truck drivers, right? Decent history, right? If you're alleging a repetitive trauma case, right? Again, no specific causal connection opinion or anything like that, but a pretty decent history. In this case, though, the petitioner also testifies about a specific injury on February 19, 2010, right? It says that on that date, right, which is about a month after first seeing the primary care physician, on that date, I was pulling down one of these stuck doors that I had been doing, you know, for 10 years before that, and this one really stuck, and when I yanked on it, oh, I felt a pain in my back. He says he calls the general manager about that, and the general manager testifies and denies that he was ever told about that particular injury. The terminal at which he's working closes down in March of that year. He picks up his final check, and he's no longer working for that employer after March of 2010. But he does continue to see his doctor, who writes a report in April of that year that says that his back problem might have been caused by his duties, right? And ultimately, he gets seen by Dr. Lorenz, and when he goes to see Dr. Lorenz, he testifies that his back has been hurting him since that 2/19/2010 specific injury, right? He doesn't talk about the repetitive trauma like he did with Dr. Massoud beginning in January 23. You know, his duties as a truck driver, the vibrating seat, you know, the fact that the door, you know, the doors stick very often, he relates it to that particular injury. He goes to see Dr. Walsh for an IME in May of 2012, and when he goes to see Dr. Walsh, the petitioner says, yeah, it was that 2/19/2010 thing that did it. That's what, you know, that's what knocked me out. That was the specific injury that knocked me out. The arbitrator denies the petitioner's claim, right, and says that the petitioner did not sustain accidental injuries on that February 19, 2010 case. But if you look at the arbitrator's decision, okay, the arbitrator says specifically that the petitioner claimed accident, the petitioner's claimed accident is both traumatic and repetitive in nature, right? So that becomes an issue in the appellate court decision because the appellate court says that even though the arbitrator seemed to be talking about a specific injury on February 19th and denied the case because of that the case would have been denied based on a repetitive trauma theory anyway. So I just want to take a minute to see what the appellate court says about that, right? It says, the claimant George Campbell filed an application for adjustment claim under the Workers' Compensation Act seeking benefits for repetitive trauma injuries to his back and person as a whole, which he claimed were causally connected to his employment as a truck driver for Dean Twig. The claimant alleged that he had sustained severe back pain due to, quote-unquote, repetitive lifting of freight, close quote, and, quote, vibration, close quote, from a broken seat of his truck. He alleged the manifestation date of February 19, 2010. So, where do you think these allegations came from? Where did these allegations of repetitive trauma come from? Was that in the petitioner's application? Was that in his original application? In other words, where it says, you know, how did this injury occur? Did the petitioner write in there repetitive trauma? Right? And is that then, you know, where the appellate court comes up with these allegations? Because ultimately, what happens with this case is that the commission affirms the denial of the benefits, or affirms the denial of the benefits. The circuit court confirms the denial of the benefits, and the appellate court affirms the denial of the benefits. Fisher uses all the way. Fisher gets to the appellate court and says, hey, wait a second. You know, when I look at that arbitrator's decision, which was summarily affirmed by the commission, I don't see that there's any discussion about the repetitive trauma, right? What I see is that the arbitrator is referring to this specific injury of February 19, 2010. There's no discussion regarding the repetitive trauma. And as a matter of law, that was wrong for the commission to do. The commission should have made specific, detailed, explicit findings about the repetitive trauma, and not just said, therefore, I find that, you know, no injury happened on February 19, 2010. The appellate court acknowledges that, right? The appellate court says, yeah, look, the Workers' Compensation Commission may not have explicitly referred to the repetitive trauma theory, may not have made any specific findings regarding the repetitive trauma theory, may not have made any specific findings, you know, regarding the manifestation date when the reasonable person would have known, right? Nothing like that. But the appellate court says that's okay, right? It's okay for the commission and the arbitrator not to specifically address one of the petitioner's theory of injury because it appeared to reject that theory, right? And this line comes right out of the appellate court, so I'm not gilding the lily or anything else. This is with the right. It appears to reject that claim as well. Okay? The Workers' Compensation Commission implicitly found, right, that there was no repetitive trauma. Can somebody tell me what an implicit finding is? How does the appellate court even judge whether an implicit finding is contrary to the manifest weight when there is no reasoning or facts or reduced to come up with the implicit finding? All right. The appellate court is telling us pretty clearly that what it reviews is the result. Right? It doesn't review the reasoning, it reviews the result. So, sometimes in my office, when we lose cases in the appellate court, we say, well, the appellate court found that it was right for the wrong reason, right? And that makes us a little angry, right for the wrong reason. Well, here's the appellate court telling us maybe right for no reason at all, right? The commission doesn't necessarily have to tell us their reasoning, and we're going to apply the manifest weight standard anyway because we apply the manifest weight standard to the result, not to the reason. So, it's a real issue for petitioners' lawyers, and you've got to be aware of it. If you're alleging one of these kind of hybrid things, right, where it's kind of a repetitive trauma injury until it becomes a specific injury, because that's the one thing that kind of, the proverbial straw that broke the camel's back, right? Maybe it's best practice to file a repetitive trauma case and a specific injury case, right? Maybe it's best to have your expert say, yeah, it could have been either one of those two things. It could have either been the specific injury or the repetitive trauma, or the repetitive trauma set him up for the specific injury. But as we saw in a case in the appellate court, a published decision a few months ago, a case called Reckenberg, right? The commission really seems to zero in on this fact that when the petitioner, insists on it being one or the other, repetitive trauma or specific injury, that detracts from the credibility of the petitioner according to the commission, right? Remember we talked about that Reckenberg case where, she alleged a specific injury and her medical expert said, well, I'd really like this case a lot better if it were, she alleged repetitive trauma and her expert said, I'd really like this case a lot better if it were a specific injury. And then she said, oh yeah, it's a specific injury, remember, at the hearing, and because she was at the deposition of the expert, remember this? Maybe no. So anyway, she said, it's at the hearing, she said, oh yeah, I think it's that specific injury that my doctor told me he really would have liked it better to be, right? And the commission said, yeah, you're not so credible when you do it, right? So, if you're alleging alternative theories, make sure that you've alleged alternative theories. And if you're a respondent lawyer, I suppose you're going to beat the petitioner up on that, right? Like, hey, pick one, right? What is it? All right, come on, right? So, all right. Any questions or concerns, issues about this one? All right. Yeah. Far be it from me to suggest anything, but all I'm saying is just be careful, right? Don't if you're just not sure, right? If you're just not sure, probably it's better safe than sorry, right? Better safe than sorry. And I'm not saying that would have made any difference in this case. I'm not sure it would have made any difference in this case. But it's something that occurred to me, right? That look, this petitioner maybe could have said, look, it was repetitive trauma until it was the straw that broke the camel's back. And then the straw that broke the camel's back, and how would the arbitrator write that decision, right? The arbitrator might write that decision, yeah, I find there was a repetitive trauma, and I find that there was a specific injury, and I defer all the findings to the specific injury case because it happened later, right? So, some things to think about. Yeah, Mark.
You can take the same approach to the manifestation date. So if you're on 8 years of date when the petitioner first came symptomatic, there's a date when he first went to the doctor, there's a date when the diagnosis was made, there's a date when his last day work. You could file 4 applications
Mark's theory is file 4 applications and let the commission decide, right? And let the commission decide even, you know, to let the arbitrator decide whether to write a decision that conforms to the proofs, right? I mean, am I right about this? I think I am, right? The arbitrator can say, yeah, that the manifestation date that you alleged on that application, that's not the right manifestation date. The proofs show, by preponderance of the evidence, that the manifestation date was actually this date. And that's still within the statute of limitations. There's still notice for that date or whatever, right? This idea of an arbitrator writing a decision that conforms to the proofs, whether that's alleged in the application or not, right? All right, good. So, talk about the major case, which is a major case, and it's a case about jurisdiction, right? So it involves the principally localized prong of jurisdiction, right? And in this case, the commission found that there was no jurisdiction under that theory of Illinois jurisdiction, the principally localized theory, and the appellate court ultimately affirms that denial of jurisdiction. So in this case, it was a Minnesota contract of hire. There's no doubt about that. So you can't do, Fisher couldn't do contract of hire jurisdiction in this case. The injuries happened in Iowa, so can't do, injuries occurring within the state of Illinois for that jurisdiction. So Fisher moved on to the third kind of jurisdiction that we have, which is this idea of principally localized. So let's just really quickly talk about the facts of the case, right? Fisher was a territory sales rep for this company that was located in Minnesota, but the petitioner almost always was in Illinois, right? He had a home office in Illinois. He did all of his work out of Illinois. When he left on a sales trip, he left from his home office in Illinois and went to the sales trip, came back to his home office in Illinois, filed all his paperwork in Illinois. In fact, spent 30% of the time in the office in Illinois, like half of every week in that home office in Illinois, doing whatever he needed to do, making phone calls or whatever. Right? Significantly, I thought, is that the respondent insured the petitioner under workers' compensation, and when you looked it up on the commission computer, right, who's the insurance company here, and it has location of business, right? The insured location of business for this petitioner was his home office in Illinois, right? So the respondent was actually insuring him at the home office in Illinois. The petitioner argues that the commission was wrong in the appellate court, and the appellate court decides this case on a manifest weight of the evidence standard. So let's just take a second to talk about that, right? Manifest weight, de novo, right? Why isn't this case perhaps a de novo case, right? I mean, it seems to me that the essential facts are not disputed, right? I mean, contract of hire was in Minnesota, right? The accident was in Iowa, right? He was insured at that location. How much time he spent there, I don't think was significantly disputed anyway, right? The fact that he always started there and came back there, right, wasn't disputed, right? So why isn't this being decided on a de novo basis as opposed to a manifest weight basis? But in any event, it was decided on a manifest weight basis. So, again, this case really represents a good summary of what the law is regarding jurisdiction. And so it tells us when you're dealing with this principally localized jurisdiction element, there's a two-pronged test that you go to, and you take these steps, right? So first of all, you decide whether the situs of the employment is Illinois, right? If the situs of the employment is Illinois, it's principally localized in Illinois, and we'll talk about how you define situs. But if the situs of the employment is not Illinois, that doesn't end the inquiry. You now move on to step 2, and step 2 is the alternative test involving domicile and substantial working time to be considered. Okay? So it's a 2-step test. And it's in this order, right? Only in the event that such situs cannot be established is the alternative test. So you don't even get to the alternative test if the situs is in Illinois, and you can only get to the alternative test if the situs is not Illinois, right? So it's this two-step process that has to be taken in that order, all right? So in this case, the arbitrator and commission had found that the situs was not Illinois, and this is what the appellate court tells us the factors are for determining the situs. And I promise I'm going to stop saying the word situs here in just a minute. So, where the employment relationship is centered, the center from which the employee works. Okay? The source of remuneration, where he's getting paid from, right? Where the employment contract was formed, right? This one puzzles me a little bit, right? Because if the employment contract was formed in Illinois, why aren't you relying on contract of hire? But in any event, where the employment contract was formed is a significant factor in situs, according to the appellate court. The existence of a facility from which the employer received his assignment and is otherwise controlled, and the understanding that the employee will return to that facility after the out-of-state assignment is complete. All right? So, in this particular case, the appellate court says factors 2, 3, and 4. So, remuneration, where the employment contract was formed, and the existence of the facility, right? Those are all in Minnesota, so those factors weigh in favor of it not being an Illinois case, right? But they don't really address, the appellate court doesn't really address factors 1 and 5, where the employment relationship is centered, which might argue in favor of it being an Illinois case, right? Because he's spending so much time in that Illinois office. And certainly, number 5, where, he's leaving the office, going on a sales trip, and always coming back to that office in Illinois. Those seem to weigh in favor of the petitioner, in this case, the Illinois case. Okay, and what the appellate court says is that ultimately, the majority of factors weigh in favor, right? 2, 3, and 4 in favor of Minnesota, 1 and 5 in favor of Illinois. The majority, 3 out of 5, 3 to 2, weigh in favor of Minnesota, and therefore it's not contrary to the manifest weight of the evidence, right? That's how the commission, that's how the appellate court decided this case, right? They looked at the factors, they said there's 3 in favor, there's 2 not in favor. That's not contrary to the manifest weight of the evidence. But I don't see in this decision where the commissioner or where the appellate court then goes on to the alternative test, right? Okay, the situs is not Illinois, but what about domicile and substantial working time? The alternative test, right? Is that, where's the alternative test? I don't necessarily see that it's considered in this decision. The petitioner's lawyer in this case pointed out to the appellate court that there's a case called Associates Corporation that is like pretty much right on point, and it's not even Rule 23, so you ought to take a look at it, appellate court, and the appellate court said, yeah, the fact that the commission didn't, consider what appears to be, a really similar case, maybe even a weaker case than this one, where the jurisdiction is Illinois, yeah, that's okay. Right for the wrong reason, right for no reason at all, kind of, right? So, any questions about this one? Any comments about this one? Yes.
I think you tell the court that we basically
I guess. But that's not the petitioner's allegation, right? So Mike points out, yeah, we decided situs, right? Minnesota, right? But that's not. We weren't asking you that question. We were asking you, is the situs Illinois? The answer is not Minnesota. The answer is no. Move on to the alternative test. Right? So that's the way I would analyze it, but I'm not correct to analyze it that way. All right. Pickowitz is a really interesting case because it involves the denial of benefits on the basis of no accident. And this is really, talk about an manifest weight case, right? This one's all, there isn't a fact that's not disputed in this case. One of the interesting things about this case is the use of cell phone data. So if you're using cell phone data in a case, to fix the location of the petitioner at a time when a telephone call is being made, take a look at this case. Any of you are fans of the podcast Serial, right? Serial number 1, right? Remember this kid who got convicted of murder in Baltimore, and there was this whole thing about, if it's pinging off of that tower, is that the closest tower to where the cell phone is located? And there's apparently a whole science about this, right? I mean, and the experts disagree. Like, you don't have to necessarily be close to that tower for for the cell phone to be pinging off of that tower. It might be rerouted to a different tower or whatever. There's an issue in this case about which tower pinged, right? And so if you have that kind of case, read this case about what it is. Interestingly enough, in a footnote, the appellate court says, they put the parties put in these cell phone records, but they didn't have any expert explain how we could use these cell phone records, and yet they went on to say that the arbitrator, it wasn't contrary for the manifest way of the evidence for the arbitrator to find that it was pinging to the closest tower, right? So they said, we don't really have information about how to use this, but the arbitrator used it correctly nonetheless. Right? So, interesting case about the relevance and admissibility of photographs, okay? Because the petitioner claimed that he fell on a stairway, but the pictures of the stairway were not taken on the day of the accident, right? And so the petitioner's argument was the photographs are relevant, right? And they're admissible. They're admissible because they truly and accurately reflect the stairway for the relevant purpose, right? And he said the relevant purpose was that it was just to show you what the stairway looked like, right? I'm not saying that was the condition of the stairway on the icy day that I fell on it, but it's relevant just to kind of show the arbitrator what the stairway looked like, and it truly accurately depicts what the stairway looked like, and therefore is admissible. And ultimately, the appellate court says, yeah, really doesn't matter one way or another because it's harmless error either way, right? I mean, whether the pictures came in or whether they didn't come in, it's harmless error. Because the respondent was saying, look, they don't truly accurately depict the way that stairway looked on the day of the accident, time of the accident, and the appellate court said, yeah, it's okay, everything, it's pretty much harmless error. Interestingly, and it's one of the only times that I've ever seen this, thank God, in my career, the arbitrator specifically found that a witness was not credible. And I'm not talking about a witness connected to the case. So what this petitioner says is, I fell on the stairway about 3 o'clock in the afternoon. I tried to, get my act together, and it was a bad arm fracture or something, right? Obvious injury, right? The petitioner meets a real estate, he's working as a janitor at a condominium association. He meets a real estate agent who's selling an apartment in that building in the parking lot at about 4 o'clock on that afternoon. And she says, oh my God, what's wrong with you? Your arm's, bent the wrong way. And he said, I just fell down the stairs over there, and I'm, trying, an hour ago or whatever, and I'm trying to get my act together to go to the hospital or whatever. So the petitioner locates that eyewitness, not eyewitness, but after the fact witness, brings her in to the hearing. That witness testifies, and the arbitrator says about encountering the petitioner in the parking lot with his arm bent the wrong way, and the arbitrator says, I don't believe that eyewitness. I don't believe the eyewitness. And it's because of these cell phone records. So what the petitioner says is that he falls, hangs out on the premises until he goes home. Before he goes home, he encounters the real estate agent. And apparently, the respondent's theory of the case, which the arbitrator accepts, is that He fell somewhere else, drove back to the job site, and said that he had fallen at the job site, and that's why he encountered this real estate agent at the job site. Because the cell phone records showed that he, during the time when he said he was hurt, at around 3 o'clock in the afternoon, the cell phone records showed that he was driving away from the facility, okay? And so these records, for which there's no expert, explanation about what they mean or what they show, are used to impeach a completely independent witness who has no, connection to the case. So it's a really interesting case that you may want to take a look at. All right. Any questions, concerns, comments about this one? All right, good. Thanks, everybody.